Have the guest here with me in Abuja. His name is Daniel Bwala. He's a legal practitioner and also a member of Lincoln's Inn in London. You're welcome to Sunrise Daily.
Thank you. Thank you. A pleasure.
Yeah, well, I think we had this conversation when his name was initially rejected.
Right.
And now he's been represented to the Senate. How do you think this is going to play out? Because for a lot of people, the first thing they see is that it would seem that the battle lines have been drawn. Do you see any battle lines here?
No, I don't think so. I think that the reason for which it was rejected must have been addressed. You recall that after the rejection, it was reported widely that the president had instructed the Attorney General of the Federation to investigate and query the the EFCC chairman, which of course was reported that he did. So for the president to resubmit the name, then it goes without saying that it's possible that the president may have, after the recommendation of the Attorney General, come to the conclusion that there is no serious allegation against him.
Now, do you think that he should be accompanying his name now with the reasons? Because if the Senate said they were in copy or in receipt of security reports, and that's the reason why they had rejected him, shouldn't they have reasons why he should be cleared as well? Yes,
but you see, I have always had the view right from the beginning that the rejection is more of a political or personal than on the facts that was presented to the National Assembly, because it was reported that two separate reports were submitted, one to the National Assembly and the other one to the office of the presidency. And that in these two instances, the reports were different. So, and you recall also when they had their, what they call the executive session, where they deliberated and decided not to hear him, and then reached that conclusion, we at the beginning thought that it was such a serious crime. Maybe Magu was trying to overthrow the government of the Federation. And that's the reason why they didn't have to bring his name to the plenary. But then later we heard that it was on the allegation of his residency, and then that he once flew first class in a private aircraft, which was owned by someone. So in a nutshell, I do not believe that there will be a problem in the Senate, because there must have been, like Chamberlain said, horse trading. There must have been a communication probably between the presidency and the principal officers in the National Assembly to the point that probably the issues are cleared.
Some very expensive horses were traded before now. I mean, when you look at the fact that Ali Ndume, who was leader of the Senate, lost his seat allegedly over this matter as well, because he had come out to say categorically that the Senate did not reject Mr Magu, that the president was going to be given another chance to represent his name, to the Senate. But it would seem that they categorically said that was not the situation. I recall the spokesperson of the House saying that he speaks for the Senate and he has the authority of the Senate on this matter. The Senate categorically rejected Mr. Magu's name. Recall also that Mr. Ndume said Senator Ndume said that he said he was not rejected because it wasn't done at plenary, a confirmation hearing where they either accept or reject a nominee. It was done, in an executive session, which was a committee of the whole, and he did not think that that was how the Senate was going to reject his name, even though the Senate eventually came out with that outcome. So how do you see this playing out now, especially with the kind of politics that has played itself out in the Senate, where has seen Senator Ndume having to step down?
There are two issues. The first one is the circumstances surrounding the rejection in the first place. The second one is the procedure for the rejection. It is common, and we all know that when a nominee, the name of a nominee is submitted to the Senate, that there is going to be a discussion, they call it a debate at the plenary, as to the propriety or otherwise of the suitability of that person for the post for which the president is nominating him. That never happened. The impression given at the beginning was that it was on, national interest or so? But we know that in a democracy like ours, and you look at the constitution of the Senate, it comprises of more than the number of individuals that sat in what they call the executive session. And so we believe that the reason why they refuse to bring him to the plenary is because there is no prima facie allegation against him on one hand.
Not because, sorry to interrupt you, not
You're
because they wanted to give the president a leeway to be able to bring him back.
Not at all. Because there is nothing wrong in bringing a candidate to the plenary, put questions to him, bring up the allegation that was, leveled against him, hear him out. If he's unable to defend it, you can reject it. And then there will be a further investigation into the propriety or otherwise of the allegation. If that is clear, he can be resubmitted. So we saw bad faith right from the beginning as to the reason why they refused to bring him to the plenary. As to the reason why Senator Ndume, bad faith. Of course, bad faith. Okay, let me back it up by telling you this. We all heard prior to the period that Magu was said to have expressed this concern that the EFCC was embarking on a mission of investigating and prosecuting even former governors, former ministers, and former senators. And when you talk of former governors and former ministers, we have quite a number of them in the National Assembly at the moment. Now, when you say you are going to investigate former governors and former ministers are in the Senate, it goes without saying that they will probably make attempts to stop you from being confirmed as a substantive chairman so as to stop this attempt to investigate them. Now, we have said from the beginning, EFCC is more than Magu. EFCC is larger and bigger than Magu. The attempt to unseat Magu was quite beyond Magu. Because it is in Nigeria, you recall in the past when Ribadu was removed and then he was replaced with someone. What happened to the cases that were pending then? They naturally died a natural death. So in this instance, we know that there are quite a number of cases that are right now on the table, some under investigation, some are being prosecuted. And if Magu is replaced, there is a 90% chance that these pending cases are going to die a natural death. And the individuals that are involved or that are under the radar of EFCC are quite powerful in the country. So that is principally the reason behind the rejection of Magu, not the allegation as it were, because later we heard that even the private jet and the MD of the bank that was alleged to have traveled with Magu to Borno State never in his lifetime traveled to Maiduguri. And we also heard that the official residence that was said to have been paid by a public officer was paid by the FCDA. So, and these are the two major allegations that were leveled against him. They also brought about the issue of his investigation when he was in the police and all of that. Are these things material? You recall that the Senate President and principal officers of the National Assembly were charged to Code of Conduct Tribunal. Did he step aside? Did the principal officer step aside? In fact, they shut down the National Assembly. The senators all went to the Code of Conduct in solidarity. So if they could give the Senate President that chance to go to the Code of Conduct to defend himself, why is the case of Magu so powerful that Magu could not be heard in the plenary? And he was at the National Assembly that morning. So there was a bigger plan, and I believe that they may not be able to reject him at the moment, because I would expect that if they reject him, the president should resubmit his name and resubmit his name until they get tired of rejecting him, because the fight against corruption has to go on.
Well, I'm going to bring to it, you've addressed one end now. The Ali Ndume end is the second end. You're talking about the procedure of the Senate and why he lost his seat.
Well, you see, I am not quite conversant with the politics in the flow of the National Assembly. And Ali Ndume's rejection as the Senate leader and the consequent replacement with Lawal, I do not want to believe it has something to do with that confession he made that the procedure was not followed by the National Assembly. It is not material enough to have him rejected. As a matter of fact, the APC caucus in the National Assembly came out to state that that was not the reason why he was removed. So I do not have the facts of the facts leading to his rejection or his removal. But if I do have, I'll be able to analyze and give you my opinion as to whether that is connected or related to that public statement that he made, against the procedure which was not followed. So
what horses were being traded here? I mean, you referred to some horses being traded.
No, I was only making reference to what Chamberlain said, but you can never rule out. It's very possible the rejection of Ndume could be a horse traded, but I don't want to make a conclusive statement about that.
Okay. Now let's look at, the status.
Right.
Some of your colleagues have taken up the status of the acting EFCC chair. They believe that after he was rejected by the Senate, he should have stepped down as the acting EFCC chair. Do you agree with them?
Well, there are two sides to it, to be honest. When he was rejected not as acting chair, he was rejected from being confirmed as substantive. If you look at the EFCC Establishment Act 2(3), it is clear that the president will appoint him, but subject to confirmation by the Senate. But that connotes, or that is referenced to the appointment as the substantive chairman of the Economic and Financial Crimes Commission. So you could argue, and rightly, that rejection was purely linked to his confirmation as substantive chair, but it does not derogate him from acting as the acting chair in that capacity. But then somebody can also argue, and rightly so, that once a candidate is rejected by the National Assembly or Senate, then it goes without saying that that person forthwith ceases to function as acting chair. So whichever side you're arguing, you can have a justifiable ground for making that argument. But I do not think that after he was rejected, he's continuing to act in acting capacity is against the law. I don't think so.